Hi, I'm Patrick Scott. Welcome back to PLS 101, American Democracy and Citizenship. Today we're going to be covering our last unit of material that pertains specifically to the struggle for equal rights. And we'll be talking a little bit sort of the historical overview of the struggle for equal rights and some of the court cases that have gone along in hand with that as well. We'll also get into some discussion about the pros and cons of certain policies that are designed to ensure equality for all Americans, such as, for example, affirmative action. And then once we do this, this will be the last segment of the material that we'll be covering for this course. Now, in terms of talking about equal rights, what I think is interesting here is that a fundamental problem of our democracy is that, on the one hand, we profess to be a nation that believes in equality, certainly. And yet, if you look at the rights that are proclaimed in the Declaration of Independence and also the rights that are proclaimed in the Constitution, are not necessarily enjoyed equally by everyone in our country. To paraphrase a famous author, some are more equal than others, you might say. Well, one of the things that we want to look at today is the question of what steps have been taken by the government to ensure the rights of minorities. And also, what is the proper role of government in protecting minority rights? Just how far should government go to help ensure the protection of rights of all Americans? I want to first of all just give you some interesting statistics about poverty among African Americans here. Despite the civil rights laws that were enacted by Congress in the 1960s, despite various decisions by the Supreme Court, many of the more than 33 million African Americans do not enjoy full social and economic equality. Just to give you some statistics here, almost 1 out of 3 African Americans in the U.S. is poor, as opposed to about 1 in 8 Caucasians. About 70% of African American infants are born to single mothers. The leading cause among black males is homicide. Black unemployment has at times been almost double that of white unemployment. And yet economic data as this do not show the many indignities that blacks often face. Even in terms of education, African Americans are likely to go to, just by virtue of neighborhood patterns, African Americans are likely to go to segregated schools. The schools are likely to be overcrowded. Oftentimes they're old. They tend to be below the academic standards of other schools. And this is occurring, of course, despite the ruling of Brown versus Board of Education in 1954. And think about race relations today. How are they today? You remember maybe several years ago, there was a Rodney King incident where Rodney King was beaten by 4 police officers. He got beaten pretty badly after he had been stopped, and all 4 police officers were acquitted. And that, as you may recall, set off a firestorm of protests in south central Los Angeles. Some 50 people died and over 2,300 people were injured, and close to 14,000 people were arrested because of this violence. We've also seen within the past couple of years more than 36 black churches in the South being burned. And so don't you find it ironic that in a nation that prides itself in the idea that all people are created equal, that we should have a problem like this? Well, what I'd like to do is take a look at this in historical perspective. If we go back, for example, to the Declaration of Independence, it states that all men are created equal, and yet that did not really include slaves who were to be counted as 3/5 of a person for census purposes. And, excuse me, and the Supreme Court reaffirmed the right to consider slaves as property in a very important case called Dred Scott versus Sanford in 1857. As you may know the background here, Dred Scott had been living for 4 years in a free northern state, and he went to court seeking to be declared a free man. In this case, the Supreme Court ruled that the Constitution did not intend for blacks to be considered as citizens. All right, and that was 1857. Now that decision was essentially overturned by the passage of the 13th Amendments, which outlawed the 13th Amendment, which outlawed slavery, as well as the 14th and 15th Amendment. The 14th Amendment made former slaves citizens, and of course the 15th Amendment gave former slaves voting rights. The one of those three amendments, the one that essentially overturned the Dred Scott decision was the 14th Amendment. But as you know, these important amendments did not change things for the better overnight. In the late 1800s, there was rampant discrimination against African Americans, and the Supreme Court really did very little to put an end to it. For example, in one ruling, the court said that the government could not discriminate against blacks, but it was okay if private individuals discriminated against blacks. There was nothing wrong with that. And that type of permissive atmosphere was what gave rise to the creation of Jim Crow laws of the South. And the Jim Crow laws were designed to keep the races segregated. So, for example, you had separate schools where you had, and you may see there's, for example, several pictures that you see here, some that show white only versus colored only. Drinking fountains, you had white-only drinking fountains, colored-only drinking fountains, restrooms, separate restrooms, restaurants that would only cater to one or the other, or if they did cater to more than one, the blacks would have to sit in a separate section in the back or come in through a separate entrance. Movie theaters the very same way. The blacks would sit at the back or sit in the balcony. So again, separate segregation in a lot of different ways. And these were all part of the Jim Crow laws that were in existence at this time. If you were riding on a bus and you happened to be black, you would be asked to sit at the back of the bus. If you were at the front of the bus and sitting down and a white person wanted your seat, you'd be asked to get up and move to the back or stand up. So the idea was you had to give deference to white people during this time. And of course, also, this period was accompanied by lynchings and terror for many African Americans. You had the rise of the Ku Klux Klan, and which again tried to keep blacks living in a state of fear and subjugation. In the late 1800s, the court also upheld the principle of separate but equal facilities between blacks and whites in a very, very famous court case called Plessy versus Ferguson in 1896. And it said basically separate but equal should be the doctrine here. Separate but equal as far as being in trains or restaurants, drinking fountains, and so forth. As long as they were equal, they could be separate. Now that separate but equal principle remained the law of the land until the mid-1950s. And by the way, separate wasn't always necessarily equal, as I've already alluded to. In the early 1950s, there was a little girl by the name of Linda Carroll Brown. She was 8 years old, living in Topeka, Kansas. She was black, and her father was disturbed that she had to go to a school 21 blocks from her home when there was a perfectly good white school 7 blocks away from where she lived. So he tried to enroll her in the school that was closer to their house, 7 blocks away, but he was not allowed to do so. And so with the help of the NAACP, he took the case to court. And the Supreme Court agreed to hear this case. And Chief Justice Earl Warren, speaking for a unanimous court, said that in the field of public education, the doctrine of separate but equal has no place. This was considered to be inherently unequal and violating specifically the Equal Protection Clause of the 14th Amendment. Now, as you know, and we've talked about this before, but compliance with the Brown case was very slow. And besides, in some of the things that I've talked about in the past, let me give you some other information about that same time that was going on. In 1957, at Central High School in Little Rock, Arkansas, violence erupted, and this required President Eisenhower to call in the National Guard. And the reason why the violence was erupted is because there were some blacks trying to enroll in Central High School in Little Rock, Arkansas. In 1962, a black student by the name of James Meredith attempted to become admitted to the University of Mississippi. He was going to be the first black admitted to the University of Mississippi. While he was trying to enroll, riots broke out and 2 men were killed. The president at the time was John F. Kennedy. He had to send troops to restore order and to protect Meredith. And he ended up sending 16,000 troops in order to protect Meredith. So just to show you just the level of violence and intensity of this going on with this integration. In 1963, Governor George Wallace of Alabama stood in the doorway of the University of Alabama and attempted to block black admission, basically saying, that no blacks will enter the portal of University of Alabama if I have anything to do with it. And then again, in my own experience, and growing up in the South, we really did not see any integration in the school district in South Carolina till about 1970. So we also see the struggle for equal rights was manifested in other ways as well. In Montgomery, Alabama, Rosa Parks, a black lady, refused to move to the back of the bus to give whites a seat in the front. And she, because of her refusal to move, she was arrested for not moving to the back of the bus. And there was a young minister at the time named Martin Luther King Jr., and he led a year-long boycott in response to this. He later went to jail, and his home was bombed. Martin Luther King Jr. also organized demonstrations in Birmingham and in 1963, and the police responded with fire hoses and dogs. So again, there's a lot of video footage from that time that shows how the police were trying to quell these demonstrations. In fact, a lot of that's a bit of dramatic video footage that you see there. At the time when Martin Luther King was arrested and he was in a Birmingham jail, there was a letter that he wrote to some of the local clergy, particularly local black clergy in the Alabama, Birmingham area, trying to explain to them his position of nonviolent protest. And I have his letter from a Birmingham jail posted on the Blackboard course website that hopefully you've read by this point. But this letter was written to fellow clergymen, and these clergymen were criticizing King, saying that his actions in Birmingham were unwise and untimely. So he took this as an opportunity to explain why he believed in nonviolent protest. And when I say nonviolent protest, we're talking about things like sit-ins and marches, things like that. And this is a beautiful piece, and again, it's something that you you definitely want to make sure that you read, because it gives you a very good indication of really the struggle and what African Americans had been going through, and why, in his view, it was necessary that we need to change our society. He talks about in that piece about laws being just and unjust, and again, as you're reading, you're going to find out about what does he say about unjust laws. What are some examples of unjust laws? When is a law unjust? All right. So you're going to be talking. So we'll be covering some material. He talks about that at length in that reading. One of the questions that comes out of this reading is that I would like to ask you is this: based upon your understanding of his reading, is it okay to violate laws that your conscience tells you is unjust? What would you say in response to that? If you were asked the question, and based upon your understanding of King's viewpoint here, is it okay to violate laws if your conscience tells you that those laws are unjust? Does that make it okay, for example, to avoid the draft? What would King say about a situation like this? Would he say it's okay for you to not obey the law, and under what conditions would that be allowed or not allowed? All right, so I want you to think about some of his writings there, and think about how he would craft answers to those kinds of questions here. Now back to our story here. In the same year, 1963, Martin Luther King organized his march in Washington, D.C., which brought about 200,000 blacks and whites to the Lincoln Memorial. And this was the place, of course, where he delivered his famous "I Have a Dream" speech. Now, about 18 days after his speech, a bomb was thrown into a black Baptist church in Birmingham and killing 4 young black girls attending Bible class. And so again, we saw the intensity here and the violence that was taking place. Shortly after all this, a our president at the time was Lyndon B. Johnson, and he signed into law the famous Civil Rights Act of 1964. And this law prohibited racial and religious discrimination in public accommodations. And so, for example, it's designed to put an end to a lot of the Jim Crow provisions that had been in place at the time. So there should be, for example, no more whites-only drinking fountains, whites-only restaurants and bathrooms, things like that. And the Civil Rights Act of 1964 also prevented employers from discriminating on the basis of race, color, sex, religion, or national origin. So in other words, in terms of employment decisions, it was designed to prevent employment discrimination. And again, that can have a really important impact economically on groups up to this point who had been historically disenfranchised in terms of economic opportunities. Now, another piece of landmark legislation happened the following year, the Voting Rights Act of 1965. And the Voting Rights Act of 1965 called for an end to things like literacy tests and poll taxes, and again, mechanisms that were designed to keep blacks from voting. And we've talked about, for example, with the literacy test. The literacy tests basically were applied selectively. Whites didn't have to take these, but blacks did as before they could vote. Often there would be, very, very difficult passages that they were required to interpret. There might be passages from the Constitution, and a potential black voter would come up and be asked to interpret these passages, which could be very, very difficult to do. And again, it was designed as a mechanism to keep them from voting, saying, well, you don't have the civic competence or to really be able to vote, and they'd be therefore denied the right to vote. So the Voting Rights Act of 1965 was designed to put an end to these kinds of attempts to keep blacks from gaining political power. And as part of it also, it attempted to eliminate the process of gerrymandering the districts. Remember the term gerrymandering? And that is taking legislative districts and drawing the boundaries in such a way that when you see pockets of African American communities, breaking and dividing them up so that they don't have the majority in a given district, that they're always kept in minority status. And again, that by default can be a very effective mechanism to keep blacks from having any political power. And so again, so we see some important advances made in both 1964 and 1965. But again, despite all of these advances, life was still hard for the average black citizen. Ghetto life was characterized by poverty and frustration. And even in 1966, there were riots in major cities, such as the Watts riot in 1966. And of course, in 1968, Martin Luther King was assassinated. Now, as part of all this, an interesting question is, well, what else has government done to respond to ensure equality, not only for African Americans, but for all citizens? And one of the things that is done in policy that's come into play has been somewhat controversial is this notion of affirmative action. And I want to talk a little bit about affirmative action. First of all, what is affirmative action, and how does affirmative action differ from, say, equal employment opportunity? And there are some differences. But basically, the question that this comes into is this: is our government and private affirmative action programs, which are designed to favor minorities and remedy past discrimination, are they constitutional? In other words, should minorities, be they African Americans or veterans or Hispanics, Native Americans or women, receive some kind of preference in terms of hiring or getting contracts? A lot of opponents say that this is simply a form of reverse discrimination, and therefore it's wrong. There's some important Supreme Court cases I want to talk about this, and then we'll go back and talk about more generally the discussion of pros and cons of affirmative action. But one of the most famous Supreme Court cases that dealt with this was called the Regents of the University of California of Davis versus Bakke in 1978. And this dealt with a court case about someone trying to apply to admissions to UC Davis, the University of California Davis Medical School. Alan Bakke, a white man, had graduated from college with a 3.51 GPA. He had served in the Marines. He'd worked for NASA in Washington, and now he decided that he wanted to become a doctor. So he applied to medical school at the University of California at Davis, but he was rejected twice. He had, again, solid academic background and solid work background as well. And both years, there were 16 out of 100 slots that were reserved for minorities. both years minorities got in with much lower scores into admission and Bakke did not. So he took his case into court. It went all the way to the Supreme Court, and the Supreme Court ended up taking a two-sided approach to this issue. First of all, they ordered Bakke admitted to UC Davis Medical School, and they said that racial quotas, very strict hardline racial quotas like the ones that were being used at UC Davis, were inappropriate. So basically the Supreme Court was forbidding the use of these strict racial quotas. At the same time, however, the Supreme Court recognized and affirmed the rights of universities to give preferences to minorities in terms of admission decisions. So since that time, the court has taken a bit of a mixed view, and affirmative action programs have come under heat lately, and their future is uncertain. Two recent cases, in fact, dealt with the University of Michigan. One dealt with its law school, involving its law school admission policies, and the other involving its undergraduate admission policies. And in these, on the one hand, the Supreme Court upheld the school's program, the law school's program. They upheld the law school's policies of using race as a factor in admissions. In the law school, the University of Michigan Law School case, the policies did not employ rigid quotas like they had at UC Davis. And in fact, there was no real specific quota system even being used. However, the undergraduate admission system policy gave an automatic extra number of points to any applicant simply based upon their minority status. And the Supreme Court found that policy to be tantamount to imposing a quota system. And so it ruled against the undergraduate policy, but basically affirmed the law school policy for admission. Now, the question I'd like to ask you and have you think about is this: do you think affirmative action is a form of reverse discrimination? You know, again, there are certainly pros and cons on both sides of the debate, and I want to make sure that you understand some of those basic arguments, both for affirmative action and against affirmative action. So let's briefly summarize some of the key arguments, both for and against. Now, again, let's define it first of all. Affirmative action defined as this: specific actions in recruiting, hiring, upgrading, and other areas designed and taken for the purpose of eliminating the present effects of past discrimination, or to prevent discrimination. In other words, positive steps that are taken by an employer that contribute toward greater employment opportunities for minorities, females, the elderly, and disabled. Now, one argument against affirmative action would be this: why are we using affirmative action to correct essentially a 200-year-old mistake? There is no one alive today who is affected. And people who are in favor of affirmative action would say that affirmative action is not an attempt to make up for slavery. It is an attempt, however, to correct for today's discrimination against minorities and women in our society that does take place, and there's evidence for that in many cases. Another argument against affirmative action: affirmative action causes unqualified applicants to get jobs, while totally qualified people are left out, based simply on their race and gender. Proponents of affirmative action would answer this by saying that the selection of unqualified candidates is not allowed, it is not permitted under federal affirmative action guidelines, and it should not be equated with legal forms of affirmative action, because that's not how it's used or practiced. And I'll even say from my own experience at our university, in terms of our hiring practices here at the university, that's very much consistent, because just to give you a quick example here, when we're hiring a faculty member in our department, we may have the top out of a whole pool of applicants, we are allowed to interview the top 2 or top 3 to bring them here to campus for an interview. And so we'll be culling the list down and narrowing it down to truly get the top candidates. Now let's say we have 3 candidates that we're going to interview, and let's say that 2 of those candidates happen to be a white male, and a third candidate is, let's say, an African American female. Now, the fact that the African American female made it into the top 3 automatically assumes a relative level of equality or equivalence to begin with. One of the candidates might have a little bit better publication record, one of the candidates might have a little bit better teaching record, One of the other candidates might have a little bit better, closer teaching match with what we're looking for in their teaching background and so forth. And so in other words, all of them have their strengths and weaknesses, and there may not necessarily be one that's superior. In a situation like that, if they all come to campus for an interview, what we're going to do is we're going to look at the candidates, we're going to interview them, have them give a research presentation, and ultimately, in a situation like this, we have the complete freedom to choose whom we will. And let's just say, for example, that one of the white males ended up doing the best job on the interview overall. Then basically, if we make that decision to select that person, we are free to do so, but basically we have to say, why did we choose this person over the other two? And so we'll basically say, well, because this person has these credentials, and this person did a better job interviewing, the person's research presentation was much better, this person's teaching presentation was better as well. I mean, a lot of different factors and different kinds of criteria that we'll use and consider. But essentially, the point is, we're not basically told that we have to, in a situation like that, hire the minority candidate, whoever the minority candidate is in this case, only that we have to basically explain why we chose the one that we did. Very, very plain and simple. And so, again, the goal of affirmative action is for minorities or females to have a fair chance. And again, it assumes that qualifications are comparable to begin with. Now, another objection to affirmative action would be that it's getting so that maybe white males today feel like they don't have a chance of getting ahead. And again, people who are in favor of affirmative action would say that in the past, if you look at businesses, for example, in the past, businesses have had a tendency to hire white males, even to the extent that in some cases, if a female or minority had a better qualifications, the white male would still get the job. A lot of people are concerned that if we do away with affirmative action, what's going to happen is that sort of your typical kinds of good old boy networks and practices will leave out anyone who is not within that same category of people. So that is some of the arguments that people was using in support of affirmative action. And furthermore, the argument is if blacks are taking all the white male jobs today, then why is it that blacks are still more than twice as likely as whites to be unemployed even with affirmative action? So again, those are some of the arguments both for and against affirmative action. Now, how does that differ from equal employment opportunity? Because they are very, very similar. And let me explain that difference there too. Equal employment opportunity, and this is what we use here at Missouri State, prohibits discrimination against anyone. It attempts to ensure that all applicants, males, females, and all races, have a fair opportunity in the hiring process in competing for promotions, and they have equal access in terms of training and professional development opportunities, and also in terms of getting hired. Now, as for affirmative action, what that is and how it differs is that is a remedy for addressing past practices of discrimination. Affirmative action was designed essentially to level the playing field for females, for individuals with disabilities, and minorities as well. And so affirmative action, again, does not mean that managers are expected to hire unqualified applicants. Now, again, I want to make sure that we understand this. And additionally, affirmative action quotas are not automatic. Even going back to the Bakke decision where the quota was pretty much thrown out. The implementation of quotas must first of all be allowed or ordered by a court of law. And a true quota situation has rarely occurred across the United States. And when they have occurred, they have been thrown out by the courts, unless the courts have a compelling reason and apply a very, very narrow kind of standard to allow a quota to exist. But it's much more the exception than the rule. And again, more often than is the case, it's affirmative action is usually implemented as a voluntary, goal-oriented program. So, in all hiring situations, equal employment opportunity principles should be applied to every vacancy being filled. Remember, and while there is a difference between EEO and affirmative action, they do have one thing in common, and they both are about trying to achieve fairness. Now, besides the struggle of African Americans throughout our history, we can look at other groups as well. We can look at the struggle for Hispanic that Hispanics have undergone, Native Americans certainly, and women. And just to show you, for example, in terms of women, they're largely because of the women's liberation movement in the 1970s, women have made some gains. And if you may remember, in 1984, we had our first woman vice presidential candidate. Remember who that is? That was Geraldine Ferraro. And today we have 2 women on the Supreme Court. But there are still very significant problems that women struggle with today. There's this idea called, the glass ceiling, for example. Often the median income for working women is lower than it is for men for a lot of different factors, but one of which has been criticized is the fact that women have not been historically granted the opportunities for promotion to the same degree men have. And so because of that, there's been this thing called the glass ceiling, and there's a limit to how far many of them can climb the corporate ladder and become top executives. And of course, we know that women still tend to dominate historically female positions, such as secretaries. So those are the few things I want to talk about in terms of the struggle for equality and how the courts have tried to deal with some of these issues throughout the history of our country. So that pretty much concludes our discussion of Political Science 101. I hope you realize, I know you probably feel this way, that we have come a long way. I mean, we've started with discussions about democracy and the Constitution and various principles contained in the Constitution. We've talked about topics of federalism and public opinion, the role of the media. We've learned about political parties, interest groups, Congress, the presidency. We discussed what bureaucracy is and how public policies are formed. And most recently, we conclude our discussion with the Supreme Court and Supreme Court decisions as they pertain to civil rights and civil liberties. Of course, the goal of this course is to help produce more active and informed citizens. And you remember what I said at the beginning of this was that the bumper sticker that I saw that says that your ignorance is their power. Our ignorance of the political system gives power to other people who know how the political system works to make decisions on our behalf, and not necessarily on our behalf. They're making it on their behalf, and we may or may not be the beneficiaries of that decisions and those decisions. And in fact, often we are not. So our ignorance is their power. Well, now, your knowledge is your power. And your power, remember this, your power is their weakness. So I want you to go out and make a difference. I want you to do something with the knowledge that you've acquired to make a better world for all of us. Thank you very much for the opportunity to share with you. I hope you learned a lot in this course. If you ever have any questions I can help you with, feel free to send me an email and let me know. This is Patrick Scott. Thank you very much.